Hi and good morning. Today we are going to present our presentation of Contract Law 2. So our group member consists of my name is which is Muhammad Azim bin NORZAHED. The second one is YUSOF bin RIDZUAN. Last but not least is Rachel TIONG, CHING. Okay, next. So we are going to read the question together. In September 2024, Aman requested a 3-month extension and an additional 1 million ringgit due to a rising material cost. Emerald agreed in writing to extend the deadline to 31 May 2035, but they, on the other hand, only provide extra RM500,000 instead of 1 million ringgit, which is conditional on progress. But they did not make any additional agreement. So, Amal progress slow significantly and stopped entirely by January 2035. So, Emerald, as a response to that, issue a 14 days notice to resume the work on 15 January 2025. Aman, on the other hand, argued that they are financially incapable to continue their work, and they blame Emerald's refusal to fund full RM1 million ringgit per requested. After that, on 5 February 2035, severe flooding destroyed several parts of the structure itself, which made the local authority impose a 2-year construction ban on them for safety and environmental review. Immediately after that, ML terminated the contract itself and they claimed for damages for the replacement of the contractor cost, delay, and lost rental income. But Ahmad argues that the contract was legally discharged by frustration and due to the flood itself and the government order. He is also claiming for 75% payment because they already completed 75% of their work itself even before the flood happened. Okay, so we are going to the next slide. So here's the brief introduction. As we can see, from what we just said just now, the parties involved is the employer, the Emerald Development Sdn Bhd, the contractor Aman Bil Sdn Bhd. So the important terms in this contract is of course time. Time was explicitly stated to be the essence, and the contract include a termination clause and a force majeure clause. So we are going to the nature of the contract itself. So the contract type is of course written construction contract. So the project scope itself is a construction of a 3-story commercial complex in Sungai Pecalang. So the financial here, original contract sum of RM12 million ringgit to be paid in 4 stages, which is based on architectural certification. So we are going to the next slide. So this is all the timeline of the event itself. So the project initiation extension is signed on January 2024. And the construction was done, 75% done in August 2024, and Emerald has paid RM9 million. In September 2024, Aman requested a 3-month extension and RM1 million extra due to rising costs. Emerald agreed, but they only give RM500,000 ringgit. November 2024 and January 25, Aman progress stopped entirely. In 15 January 2025, Emerald served a formal 14 days notice to resume the work, but Aman state that they are financially unable to proceed. Last but not least, in 5 February 2025, severe flooding heavily damaged the unfinished structure. And last but not least is after the flood itself, which is local authority issue a mandatory 2-year construction prohibitor order for safety and environmental review. Last but not least is Emerald terminates the contract and they claim for damages. But Aman replies by arguing that the contract was discharged by the frustration. Okay, so I'm going to the next slide. So the legal issue that arises here. Okay. The first one, the Aman delayed the work stoppage, which is constitute a repudiatory breach. The second one is the informal September 2024 arrangement were legally binding. The third one was the contract discharged by the field survey flout and the government bank itself. The fourth one, whether Emerald's termination towards Aman is a valid termination or not. Last but not least, what can Emerald claim in damages, or what can Aman claim for work done? Today I'm going to present the first issue, which is the Aman breached the contract by delaying the progress of the work and completely stopping the work between November 2024 and January 2025. Okay, we're going to the next slide. Okay, the first relevant law is Section 56, Subsection 1 of the Contract Act 1950. It states that one time, if the essence of the contract, the failure to perform within required time allow the innocent party to terminate the contract. This can be seen in the case of Tan Hakim versus Haji Hasnan, where the court held that a completion date alone does not automatically make the time become an essential clause in the contract. Time only becomes essential to an express clause, reasonable notice to perform, or the nature of the contract itself. The second principle concern or is about repudiatory breach. Okay. So here I'm using the case of Rasia Munusami versus Lim Tan and Sons, where the court states that a mere delay or a genuine dispute is not enough to amount to repudiation. Instead, there must be a clear refusal or inability to perform their contractual obligation. I'm also using Section 40 of Contract Act 1950 that provide when a party refuse or disable themselves from performing the contract by entirely, the innocent party may terminate the agreement. So, by applying this principle, Emirates contract expressly state that time was an essence. Although Emirates granted an extension until 31 March 2025, Aman later stopped the work completely. Emirates then issued a 14 days notice requiring Aman to complete their work. Unlike the contractors in the case of Tan Hakim, Aman completely failed to resume the work even after receiving such notice. Furthermore, Aman admitted financial difficulties and were unable to continue the construction. This situation itself is very different from the case of Rasia Munusami because Aman did not merely delay the performance. Instead, he completely ceased the work and could not fulfill his own obligation. Therefore, his conduct amounted to an equivalent refusal to perform. Okay, the second principle concerned about repudiation breach in the case of Rasia Munusami versus Lim Tan and Sons, where the court states that a mere delay or a genuine dispute is not clear enough to amount to repudiation. There must be a clear refusal or inability to perform contractual obligation. So I'm using Section 40 of the Contract Act 1950, which will further provide that when a party refuses or disables itself from performing the contract entirely, the innocent party may terminate the contract. Next, we are going to the next slide. By applying this principle, Emirates contract expressly stated that time was an of essence. So, technically, time was the essence of the contract. Although Emirates granted an extension until 31 March 2025, Aman later stopped the work completely. Emirates then issued a 14-day notice requiring Aman to continue the work. Unlike the contractors in Tan Hakim, Aman failed to resume the work even after receiving notice. Furthermore, Aman also admitted financial difficulties and was unable to continue construction. Next slide. This situation is also very different from Rasia Munusami because Aman did not merely delay the performance. Instead, he completely ceased the work or the performance of the contract and he could not fulfill his obligation. Therefore, his conduct already amounted to an equivalent refusal to perform. Next slide. In conclusion, Aman had already committed a fundamental and repudiatory breach of contract. Emerald was therefore entitled to terminate the agreement under Section 40 and Section 56 of the Contract Act 1950. Now I'm going to present the second issue. So the second issue is whether the September 2024 arrangement for an additional RM500,000 and a 3-month extension is legally binding without a formal supplementary agreement. The first relevant law is Section 36 of the Contract Act 1950, which states that an agreement without consideration is generally void. So I'm using the case of Williams versus Roffey Bros, which in this case the court held that an additional payment may be enforceable if the promisor receive a practical benefit such as avoiding delay, and the agreement is not made under economic duress. So we are going to the next slide. So by applying this case, Ahmad may argue that the emigrant obtained the practical benefit because the extra payment may encourage the completion of the project itself and it help avoid rental loss and delay. However, the additional payment was conditioned upon Ahmad and maintaining and reasonable progress. Thus, Ahmad failed to satisfy this condition because he stopped work entirely between November 2024 and January 2025. In addition, under Section 26, Ahmad was already contractually obligated to complete the construction work. Therefore, there was no clear, fresh consideration supporting the additional payment arrangement. As a result, Ahmad cannot rely on the case of William versus Rofi Bruce just because he failed to provide practical benefit that would justify the additional payment. Next slide. In conclusion, Emirates promised to pay the additional RM500,000 was a conditional and was never formalized through a supplementary or additional agreement. Since Ahmad failed to maintain the work progress and ultimately stopped the work, Emirates is not legally required to pay the additional sum. That's all for me. Next, I will pass to the next person.
Good afternoon, madam. I'm Rachel, and I would like to discuss about the frustration part. The issue is whether the construction contract between Emirate Development Sdn Bhd and Amanbil Sdn Bhd was discharged by frustration following the severe flood on 5th February 2025 and the government prohibition order shortly thereafter. There are several legal principles and authorities. The main governing provision that relates to the concept of force majeure is Section 57 sub 2 of the Contract Act 1950. Section 57 sub 2 of the Contract Act 1950 provides for the doctrine of frustration. Under this section, a contract becomes void when, after it is made, some event occurs which could not be prevented, makes the performance of the contract impossible or unlawful. Under the Contract Act, the term frustration is not used. However, the courts have applied English cases on frustration in interpreting Section 57 sub 2 of the Contract Act, which has been accepted as providing for the doctrine of frustration. In Lee Sang-Hock against Fatima binti Zain, the Court of Appeal referred to the doctrine of frustration, which has since received statutory recognition in Section 57 sub 2 of the Contract Act. In Tai King Yu and others against Sentor Raya Sdn Bhd, the judge said that the common law doctrine of frustration is codified in our law in the form of Section 57 sub 2 of the Contract Act. The Contract Act does not define the word impossible provided in Section 57. However, most Malaysian cases has applied the test formulated by the House of Lords in Davis Contractors against Fairham, where Lord Radcliffe stated that frustration occurs whenever the law recognizes that, without default of either party, the contractual obligation has become incapable of being performed because the circumstances in which performance is called for would render it a thing radically different from that which was undertaken by the contract. In Malaysia, the House of Lords decision in Davis Contractor case was applied by the Federal Court in Ramli bin Zakaria and others against Government of Malaysia. In Kershaw, Anup Chan Mehta and others against Abra Finance Bhd and other, the tenancy agreement was frustrated due to the merger exercised by the Bank Negara. In Tang Akim against Haji Hasnan, Justice J set out 3 conditions where time is considered to be the essence of the contract, and one of the situation is the parties state in the contract that time is of the essence of the contract. Section 40 of Contract Act provides that party is in breach of a contract if he refuses to perform in its entirety, and the promisee may put an end to the contract. In Lovelock against Franklin, the court held that the repudiation can be implied from the conduct of the defaulting party. Move to the application part. Aman tried to rely on the force majeure clause to discharge himself from the contract because if the force majeure clause apply, the doctrine of frustration will come into play. Aman contends that the contract was discharged by frustration because on 5th February 2025, severe flooding and the local authority prohibited all further construction activities, and this event occurred after the contract has been formed and were beyond his control. If Aman succeeded, he will no longer need to construct and complete the remaining 25% of the construction work. The contract was discharged by frustration because the frustration will discharge Aman from all future obligations after the supervening event. No doubt that the severe flood and the local authorities' order of prohibiting all further construction activities are recognized as a supervening event which could not be prevented and makes the performance impossible and also unlawful, which the scenario come under section 57 sub 2. The flood which destroyed substantial portions of the partially completed structure will surely make the further construction radically different from that which was undertaken by the contract, which satisfied the test formulated by the House of Lords in Davis contractor's case, which was applied by the Malaysian court to interpret the word impossible in section 57 sub 2 of Contract Act. However, this argument is not available to Aman because when Aman ceased construction in January 2025, there is also no circumstances in which the construction is radically different from that which was undertaken by Aman in the contract for the doctrine of frustration to apply because the flood and local authorities prohibition only happened on 5th February 2025. The court in Khrushchev's case allowed the frustration because the defendant there did not breach the tenancy agreement as he was paying the rental before the supervening event, which was the merging exercise of the Bank Negara, resulting the defendant has to surrender its license, therefore cannot operate the business affairs at the plaintiff's premise. In here, Aman's progress slowed significantly between November 2024 and January 2025, and eventually ceased the construction completely, notwithstanding that time is of the essence is stated in the contract, and therefore the time is of the essence of the contract under the condition set out by Justice Gill in 10 Akin case. So, Aman who is in breach of the contract before the supervening event cannot rely on the doctrine of frustration. Aman has completely stopped the construction work in January 2025 and did not resume work, notwithstanding that Emerald issued a formal notice on 15 January 2025, demanded Aman to resume work within 14 days, and Aman failed to resume the work after the expiry of 14 days. Bear in mind that the supervening events only happened on 5th February 2025. So, apply the Lovelock case principle to the scenario here. Aman's conduct implied that he had repudiated the construction contract. Aman's serious breach of the contract have resulted in Emerald terminated the contract on 10 February 2025, which Emerald is entitled to under Section 40 of the Contract Act. So, Aman cannot rely on the doctrine of frustration. The High Court in Universal Corporation against Five Ways Properties had held that the doctrine of frustration not apply merely because a party finds that he does not have the money to complete a contract. The High Court in Tai Kin Yew and others against Santo Raya Senjam Bahat held that the economic crisis, the consequential dire financial system situation were insufficient for the doctrine of frustration to apply. Move to the application part. Between November 2024 and January 2025, Aman's progress slowed significantly and eventually ceased entirely. On 15 January 2025, Emerald issued a notice alleging serious breach and demanded that Aman resume work within 14 days. Aman, in response, admitted that he was financially unable to continue the project. That is insufficient for the doctrine of frustration to apply under Universal Cooperation case and Thai Kim Yew case to discharge Aman from the contractual obligation. In conclusion, Aman could not rely on frustration because at the time when Aman ceased construction, there is no supervening event which made the construction radically different from what was undertaken by Aman in the contract. Aman had already breached the contract before the frustrating events occurred, making him liable for his defaults. Notwithstanding, the flood and government prohibition order fall within the scope of the force majeure clause as acts of God and government intervention. However, the force majeure clause will not discharge Aman's contractual obligation or mitigate Aman from liability because his delays and failure to continue construction had already occurred before the force majeure events arose. That's all from me. Thank you.
The issue is whether Emerald is entitled to damages following Aman's breach of contract and whether Aman can successfully claim any further payment after the contract was terminated. As for the relevant authorities, the primary provision is Section 74 of the Contracts Act 1950, which provides that when a contract is broken, the innocent party is entitled to compensation for losses that naturally arise from the breach or losses that were within the contemplation of both parties when the contract was formed. The statutory principle is based on the landmark English case of Hadley against Baxendale. In that case, the court held that the damages are recoverable only when the losses are either naturally from the breach itself or were reasonably contemplated by both parties at the time the contract was made. Therefore, not every loss suffered is recoverable. Losses that are too remote will not be compensated. On the application of the principle as seen in the case of B1 Rubber Factory Sdn Bhd against Lou Sam Moy, where the court held that the purchaser could recover losses resulting naturally from a delay in completion as to include accommodation expenses. This demonstrates that losses directly flowing from a breach are generally recoverable. Similarly, in the case of Malaysian Rubber Development Corporation Berhad against Glove Seal Sdn Bhd, the court reaffirmed that Section 74 is a statutory embodiment of the rule in Hadley against Baxendale. The court further emphasized that damages may be recovered where the loss was reasonably within the contemplation of the parties when they entered into the contract. In addition to this, there is the case of Robinson against Harmon that establishes the fundamental objective of contractual damages. The court held that damages are intended to place the innocent party in the same position as if the contract had been properly performed. In other words, the purpose of damages is compensatory rather than punitive. As for the application of the case, applying the principles of the facts, Emerald is likely entitled to recover the cost of appointing the replacement contractor. Aman significantly slowed its progress between November 2024 and January 2025 and eventually admitted that it was financially unable to continue the project. As a result, Emerald was forced to engage another contractor to complete the remaining 25% of the works. Applying Robinson against Harmon, Emerald should be placed in the same position as if Aman had properly completed the project. Therefore, the additional costs incurred in completing the project are recoverable. Furthermore, under Section 74 and the first limb of Hadley against Baxendale, such losses arise naturally from Aman's breach and are therefore not too remote. Emerald may also recover delay-related losses. Although Emerald granted Aman an extension of time until 31st March 2025 and agreed to an additional payment of 500,000, Aman failed to maintain reasonable progress and eventually ceased construction altogether. Similar to B1 Rubber Factory against Lou Sam Moy, where losses resulting from delayed completion were held to be recoverable, Emerald may claim losses that directly resulted from the prolonged construction period, such as additional project management and administrative costs. In addition, Emerald claimed losses of anticipated rental income from the commercial complex. Applying Hadley against Baxendale and Malaysia Rubber Development Corp against Glove Seal, such losses may be recoverable if they were reasonably within the contemplation of both parties when the contract was formed. Since the project involved the construction of a commercial complex, it is reasonably foreseeable that Emerald intended to generate rental income from the completed development. However, Emerald must still provide sufficient evidence to prove that the amount of rental income lost and show that the claim is not merely speculative. Turning to Aman's position, Aman is unlikely to recover the additional 500,000 promised by Emerald. This is because the payment was expressly conditional upon Aman maintaining reasonable progress on the project. The fact clearly shows that Aman failed to satisfy this condition as the construction slowed significantly and eventually stopped together. Therefore, Aman cannot enforce the promise of the additional payment. Finally, Aman may argue that it is entitled to further payment for the work already completed. However, Aman had completed approximately 75% of the project and had already received 9 million, which represents 75% of the 12 million contract price. Applying the compensatory principles in Robinson against Harmon, Aman has already been paid proportionally for the benefits conferred. As such, any claim for further payment is unlikely to succeed. In conclusion, the remedies available in this case largely favour Emerald. Applying Section 74 of the Contracts Act 1950, together with the principles established in Hadley against Baxendale and Robinson against Harmon, Emerald is likely to entitled to recover the reasonable cost of appointing a replacement contractor as well as losses resulting from Aman's delay in completing the project. Emerald may also claim loss of anticipated rental income, provided it can establish that such losses were reasonably foreseeable and supported by sufficient evidence. On the other hand, Aman's claims are unlikely to succeed. The additional 500,000 was expressly conditional upon maintaining reasonable progress, a condition which Aman failed to satisfy. Furthermore, Aman had already received the 9 million, representing the approximately 75% of the contract price for 75% of the completed works. Therefore, any claims for further payment would amount to overcompensation. Accordingly, Emerald is likely to succeed in his claim for damages, while Aman's entitlement to further payment is minimal.